Eve. Joining us now, Ole Miss law professor Christopher Green. Good morning there, Professor. Thanks for coming on. Busy morning for sure with this SCOTUS opinion being handed down on affirmative action being used in college admissions. What's your first reaction there?
Well, good morning. I guess my first reaction is this is what we've been waiting for. We've been expecting it in something like this shape since the oral argument. It seemed pretty clear when they heard this last fall that we were in for some changes. So as a law school, we're obviously, the first thing we think is, okay, what can we do? So I'm a little bit glad not to be on our admissions committee to have to figure this out. Really, the general counsel of every university, especially the SEC folks, they're going to be looking at this, figuring out what can we do. So my initial thought, I look at it and I think, well, what can we do? It does seem to allow a lot of not racially conscious, but kind of racially sensitive, or I don't know how quite to put it. You're allowed to ask people to tell stories about their experiences. You can't just automatically give a benefit to people of a certain racial group, but you can say, hey, have you had experiences where people, experiences related to your race, and tell a story, and then I don't know if we're going to be using AI to read these essays and give their best shot. So I don't know if Skynet's going to help this, but it looks. It wasn't nearly as categorical as it could have been. It could have been okay, Title VI says no consideration of race. They did not go that way. Justice Gorsuch suggested that he wanted to just base it on the statute, but the majority did not. It's kind of a funny one aspect. So Harvard, right? Harvard is not a state. It's not subject to the Constitution, but it gets federal money. So it's subject to the Civil Rights Act of 1964, which says no discrimination based on race. So they had to have a holding related to the statute. There's this footnote 2 in the majority opinion where they say, well, the statute means the same thing as the Equal Protection Clause. All the stuff we say about the Constitution just kind of applies over to the statute, even though Justice Gorsuch questions this. Justice Gorsuch actually joins that footnote. Gorsuch and Thomas, they have a concurrence questioning it, and then a footnote joining it. So I thought that was a little bit funny. But they could have written it. One of the possible things that we were thinking might happen would be, well, Congress has spoken. If you're unhappy with this, go to Congress. But they did not do that. They said it's constitutionalized. Congress is not free to just revise this by putting an exemption into Title VI or Title VII. It's a kind of murky question, what exactly we're allowed to. There's a footnote about the military academies. So, well, maybe, the need for a racially diverse officer corps, poses different things. The basic thing they said is there's no endpoint. So because you have a policy that just kind of continues indefinitely, with even though it's subject to periodic review, that's not enough. But of course, what we could do, we could just say, oh, we're going to have affirmative action for next year. Okay. And then a year from now, I'll say, we're going to, just have a policy that sunsets automatically after every year. The whole, it's got to have an endpoint, really never made much sense to me as a reason, unless you're talking about a remedial justification, which they're not talking about. So I find it kind of, every time I explain this to first-year law students about, these 2003 cases, the two of them, one of them strikes down a thing for being too rigid, and the other says, well, this other program is okay because it's flexible. The two University of Michigan cases. I always say, I can't really, what is this? Why does it have to be flexible? Why is flexibility good when you're in theory you're saying it's got to be narrowly tailored? That how can it be narrow but flexible? So I for many years explained how that doesn't make any sense to me, and I suspect I'll be explaining for however many more years why I can't really make much sense of this rule. But that's that's the kind of thing that happens. So I think
the term that I'm hearing tossed around by lawyers in the news, about this, what I consider kind of the door still a bit open, to your point a minute ago, was if you've experienced any challenges, if you can share any direct experience with racial discrimination, you could incorporate that in your essay, in your application, and the schools could consider that. But, Professor,
right. Yeah.
That's awfully subjective. And how do you go about determining whether or not that's actually true? How do you prove that? That would be that comes to mind. An admissions organization, how are they going to do that? And again, how does that factor in? Well, because this person was discriminated against one time, 20 years ago when they were a child, we're not going to let them in. That's probably too long. But 15 years ago, we're not going to let them in, or we're going to let them in, or something like that. Seems so subjective.
All kinds of questions like that. Yeah. And so I say, dance like nobody's watching and write your emails like you're reading it aloud in a deposition. Anybody, on the admissions, and I'm really genuinely glad not to be on the committee, but I mean,
it's thorny.
Oh my goodness. Yeah. So
it's thorny. So Asian applicants are saying that they were seeking counsel from just consultants to help them draft their essays and their application to try to hide the fact that they were Asians to Harvard.
Oh, absolutely. You look at, if you think if you're like naming your kids, if you're trying to kind of fit in and look like kind of just generic person, you're genuinely thinking, if you care about, what their life's going to be like 18 years from now, you actually, you genuinely have an incentive to change your name, or like go by a middle name or have a nickname that's, sounds more Anglo. I mean, it really is, it's really unpleasant. And the Harvard stuff, I don't think they got a whole lot into it, but there were some really unpleasant aspects to the Harvard. Just they have these personality scores and the racial.
We talked about that.
Really did not look good for Harvard. So I haven't read through the whole thing, but I don't think they got hammered quite as bad as they maybe could have been.
Justices Alito and Roberts did hammer Harvard's lawyer, Mr. Waxman, specifically about that personal score system, and said, gee, we look at the scores here. I guess they obtained that just through normal evidence gathering, and said it appears that you consistently score your Asian applicants lower from a personal score perspective.
Justice Alito, the argument said, so what's your view that, Asians are unpleasant or something?
Right.
It was very, very sharp.
But how do you score? How do you score an applicant's traits such as integrity and things like that are entered into that personal score? How in the heck can you possibly know that about an 18-year-old, or maybe they're trying to get into law school or something? They're 20. How do you do that?
Admissions always has these subjective elements. You look at these letters of reference from different people. I'm always, when I would look at these letters, I would almost always be looking especially for professors, saying like, okay, you got an A, but like where in the A range? Is this at the top of the, just kind of looking for really more specific things about performance in the class. But some of these personality things, I write these letters and I say, hey, when I'm, it's saying somebody should hire somebody for a clerk, saying, hey, they're a pleasant person. They're going to be a good person to work with. And that's based on, all kinds of really subjective things, but it is something you care about. This isn't going to be, somebody who's just grumpy about stuff.
But who as an applicant gets somebody to write a letter of recommendation for them that would exhibit and convey poor personal traits? Who does that?
Yeah.
Those people's letters don't end up in those packages.
Yeah. So if you get a letter from, the important people, it's going to be helpful. So, but again, this is kind of how it's always been. To get in the military academies, you got to convince your congressperson to recommend you, and you just, who knows what you're going to need to do that. Having the right grandpa certainly helps. I really do wonder if AI is going to come in and especially to the extent. I mean, we're a small state. We haven't gotten sued about our programs, in a long time. Obviously got lots of litigation in the 60s and 70s about that stuff.
Right.
But, in terms of just like if I'm in Texas,
right.
if I'm in Florida, these big states where they're likely, North Carolina, likely to be lots of litigation, I would think, hey, let's just maybe turn this over to the machines. See how the machines do it.
Well, Professor, you know what's going to happen? AI is going to generate the essays and help prepare the application, and then AI is going to score it using the same data, right? The same learning material. We got a break right here. Want to come back and talk to you about other rulings that we're waiting for as well, such as the student loan ruling. We got law professor Christopher Green on with us at middays. We're coming right back. We've got law professor Christopher Green on with us. So, Professor, do you see this matriculating into other areas of society? And it doesn't seem like this is just going to be limited to just higher ed admissions, huh?
Oh, no, goodness. I mean, so the Title VI aspect of the case, I mean, anybody who touches federal money is going to be affected by it. So, there's the biggest aspect of it is colleges and professional schools, but there's lots of other federal contracting that's involved. So, and just generally, Title VII applies to all the workplaces. So disputes about that are not going anywhere. Of course, the big Bostock case from a few years ago, Justice Gorsuch had a very aggressive reading of Title VII there, and it fit. He cited Bostock a whole bunch of times for a more aggressive reading of Title VI in terms of saying, hey, look, Congress said don't do this, and there are many bumpy roads ahead.
Yeah. It seems like it would, but, something that comes to mind, you mentioned about Title VI federal money makes total sense. But what about the federal government itself as an employer, which has instituted really broad, sweeping, and fairly onerous, honestly, affirmative action policy? The Department of Personnel, whatever that department is, it promulgates those rules, essentially the HR department for the federal government. So we're already seeing this at play across the agency spectrum, and some of that was due to executive orders when President Biden took office. Is it going to apply to them too?
Since 1995, so we had a 5-year period between 1990 and 1995 where they said, maybe the affirmative action rules don't really apply to the feds in quite the same way. But since this Adirondack case in 95, in theory, the federal government is subject to the same requirements. Okay. A year ago, they had a case about federal government discrimination. It was discrimination against Puerto Rican citizens, but Justice Thomas actually there had a long concurrence explaining why citizenship is the right category for discrimination by the federal government. They've had racial preferences in like the Bureau of Indian Affairs. They have things saying tribal members or people with tribal ancestry get preference in hiring by the federal government. They that case from 1974 said that's okay, but it's possibly on some wobbly foundations. That's the kind of issue where Gorsuch and Thomas might really depart and have an interesting conversation between them, like they did in the Haaland case a bit ago.
Here's something. Let's bring this home for a second, Professor, and get you to weigh in on this. There are public sector entities in the state of Mississippi that receive federal money that they then use in contracting with outside vendors, external vendors, through a procurement process where they give preferential treatment to those bidders that either are minority-owned from minority-owned companies, and there's a definition of what constitutes minority-owned, or have a certain amount of minority participation in their proposal. Might this invalidate those laws as well, or those policies, I should say?
Yeah, people who are litigating those, definitely, they're going to be, they're going to be looking through to see what ammunition they might be able to get. I mean, the ESG score stuff.
Yeah.
With these investors saying, "Oh, we're gonna look at all the stuff you're doing." To what extent, if you're a public pension system, making investment decisions based on that, depending on what you can figure out about how that works, you could definitely have problems. So, so there's some state statutes that have been proposed or enacted limiting reliance, and then there's just constitutional Title VI litigation about it. So, unfortunately, it makes people have to spend a lot more money on lawyers. I always say we just need to be coming up with rules that help us work ourselves out of a job. But the human condition, we don't work ourselves out of a job. What I want to like figure out the history in a way that like people don't have to write the history anymore, because we all know it, because Green figured it out. But it tends not to be that way. We like to set up a little place where we can be the people still in charge and suppress competition, raise prices. That kind of tendency operates in the law, as well as the productive parts of the world.
Well, as you know, the federal government they employ those policies in their procurement practices as well. I've been a vendor to federal agencies where I've been 5 and 6 removed as a subcontractor to the contractor, all the way up the chain to the prime contractor who simply won the contract because they checked some boxes. And that's kind of the slang, I guess, you hear around this whole issue, is checking the box, so to speak, even today. Yep. And so I just wonder, are they going to continue those practices?
Yeah, so I mean, it's related to all these questions about like the student loan debt and just the administrative state. Why and part of it, I mean, it raises the stakes for these presidential elections so much that when you get a president, he's going to put all his or her people in charge, and just huge numbers of things are not actually specified in the statute. If we had a serious non-delegation doctrine that said, look, Congress has got to pass a statute and actually say what it is. What do you need an executive for? You need it for secrecy and dispatch. So you can do stuff secretly, you can do stuff quickly. None of these policies about, these they take years to go, and they're done all in the open. Congress could have done these things. So if you had a Congress that was more energetic about preserving its own prerogatives, and you had a court that was just like, look, you can't just transfer legislative power to the executive whole hog like you've been doing. If you had that, I think you'd have a more stable system, because you'd have to get a compromise. You'd have to cobble together a group, and it's not going to just you wouldn't be just rolling the dice every 4 years about what personality quirks you get from the various folks who end up being president. So I think,
to be honest, as you know,
a separation of powers would be good.
It's both parties, as you know. It's both parties. This practice isn't unique to one particular party. It's both parties have used that power of that pen, and issued just mountains of executive orders, which affects us more, honestly, than the laws that Congress passes. I don't think that was the intention.
Yeah, the pen and the phone stuff. There's this great, Saturday Night Live cartoon. It's a parody of "I'm Just a Bill," and
right.
I'm an executive order, and I pretty much just happened. And like, really, that's how we're doing this. But we've been doing it for a long time with and the presidents of both parties, Congress people of both parties say, "Oh yeah, let's just kick it down the road. All we need to do is, get material for, be able to run a campaign ad saying, oh, I'm fighting," but you're not forcing them to come up with a resolution in the statute.
That's exactly right. We got about a minute left. So the only case I'm aware of was this one the court ruled on, filed by the state of West Virginia, right, against the EPA, where the EPA overextended its authority that Congress essentially granted it through a law, and they just kind of hijacked that and did a bunch of other stuff.
Yeah, I don't know if there's always some people, anybody who's unhappy with the regulatory state is going to be making these non-delegation challenges. I don't know exactly if they have what's in the pipeline, but I would think that that's something that a lot of people are interested in looking at. But it relates to, I mean, this whole the Biden loan cancellation. They could have, they could
tomorrow,
have
right? We're getting the ruling on that.
Noises. Yeah.
Before we go, what's your opinion? What do you think's going to happen?
I don't know. They might say that nobody has standing, so they might say he'll be able to get away with it, even though it's weird because like the threshold, by far his most likely way to win would be to say they're not going to hear it. But once you say that like Missouri's loan servicing people have standing and the state of Missouri can assert those, if they do that, something like that, seems likely that they'll strike it down. But but that case is a big one. The 303 Creative on the websites for
web designer
for weddings is a huge one.
Same-sex weddings.
But there's opinions coming out tomorrow, so we'll be waiting at 9 a.m. Central, 10 Eastern.
Well, I'm sure we'll get you back on to run through those. I really appreciate your analysis and your insight as always, Professor. And again, I look forward to talking to you again about these rulings we're going to get tomorrow. It's a busy week for the Supreme Court, to say the least. Thank you, sir. Appreciate it.
Good to you. Take care.
We're coming right back with more here on Middays in the Element Wealth Studio.